Greetings. I hope you're having a good day. I'm starting to feel a little bit more comfortable with this format, although I really miss having my students with me. Just talking to you from my kitchen table is certainly a poor substitute for actual seeing you in person, but I will do the best I can. Now, in this lecture, and I think in the next lecture, I'm going to be deciding a case. Now, the place to get started is that if you look at your notes, in a typical year, there are 8,000, maybe even more requests for Supreme Court review. That's a lot of cases. And interestingly, the Supreme Court only holds oral arguments and actually decides about 80 of those cases. So essentially, the Supreme Court takes about 1% of the cases that are requested for review. Even though the vast majority of cases are decided at the state level, I don't know, depends on the year, maybe 60, 70, 80 million cases are decided in state courts, and there are about 500,000 cases decided in federal court. When it comes to Supreme Court cases and Supreme Court review, about 2/3 of the cases that the U.S. Supreme Court accepts for review actually come from the federal court system. They come from the U.S. Court of Appeals. The other third, about 35% of all cases, actually come from state Supreme Courts. So even though most of the action is at the state level, when it comes to cases on appeal, most of them actually come up through the federal court system. So let me give you the first Randall story. Hopefully you've missed them a little bit. I want to talk about a case, and I'll use this case to illustrate most, but not all of the principles in this section. So the case involves a celebrity. Her name's Muhammad Ali. I had the good fortune, obviously, to be born in the same town as Ali, although interestingly, I didn't meet him in Louisville. I met him in Sacramento. And in this particular case, Ali was doing a charity function. And in this particular case, people were in a very, very long line to get things autographed. So I snuck behind the line. He was sitting in an area, there was a little plastic behind him, and I pulled the plastic aside. As you might imagine, security came running, and I said, "Champ, I'm a college professor. I would stand in line and wait to talk to you, but I've got a class to teach in about an hour. But I've got to know if the story about you in Joe Rubin's drugstore is true." And about then, the security guards grabbed me, and the champ kind of looked at them and kind of motioned his hand like, no, nobody would know about Joe Rubin's drugstore except somebody who knew something. So he came up to me and he motioned for the guards to let go of me, which they did. And I said, "Champ, the way I hear this story is that many years ago, before you won the gold medal in Rome, you used to ride your bike down to Joe Rubin's drugstore. And you would go in, and there was a kind of a crotchety guy that worked there who would kind of hassle you because you would read the magazines and you would read the newspapers, but you'd seldom buy anything. So after a while, the guy would run you out, and usually run you out to your bike. And I want you to know that that crotchety guy was my dad." And he smiled real big and in a deep voice said, "I remember him." And I said, well, my dad could exaggerate, so I didn't really believe the story until I asked my mom about it, and she said, "Oh yeah, yeah, I sat next to him many, many times. In fact, I uh, I even talked to him when I was pregnant with you, and he was a delightful young man, and we chatted many, many times. We were essentially the same age, as it turns out." Uh, So when I asked Ali about this, he said a long time ago, and I said, "So the story is true?" And he said, and he nodded his head, "Yeah," and it was really intriguing. So Joe Rubin was actually, I'll talk about him later in civil rights. As you can guess, in the 1950s, Kentucky, as I told you, was a very segregated society. Louisville was very segregated. Joe Rubin was a childhood friend of my dad's. Joe Rubin, as you can guess by the name, was Jewish. Unfortunately, he had several distant family members who in Europe had died in the Holocaust. And Joe Rubin was one of the few businesses in downtown Louisville that was integrated. He would serve both black and white customers, and he faced a lot of discrimination. I'll tell you some of the things that happened to his drugstore later on. But anyway, I thought I would tell you my story with Ali because I'm going to use his case to illustrate this. Now, as you know, Ali was stripped of the heavyweight title for a couple of years because he refused induction into the military. He objected based on being a conscientious objector. The case went to the U.S. District Court, the lowest of the federal courts, where the federal court ruled that Ali did not meet the threefold criteria to be a conscientious objector. So the case was appealed to the U.S. Court of Appeals, where once again the court ruled that Ali did not meet the threefold criteria to be a conscientious objector. The case was then appealed to the U.S. Supreme Court. Now, if you take a look at your notes, the place that the action begins is that the discussion list is drafted. There are thousands and thousands of cases that are appealed to the Supreme Court, and the first and most important task of the Supreme Court is to filter through these cases and decide the cases that they are going to decide to hear. The Chief Justice controls the agenda of the court through the discussion list. So the Chief Justice's four law clerks help him go through this list. The other justices also have law clerks. The Chief Justice then sends out a list of the cases that he thinks are worthy of discussion. His colleagues at times may recommend cases to be added to the list. The Chief Justice usually, as a professional courtesy, will do this, but he doesn't have to. Now, in the case of the Ali case, the Chief Justice was a man named Warren Burger. And Burger decided, like the Court of Appeals and like the U.S. District Court, that Ali did not meet the criteria to be a conscientious objector. So Chief Justice Burger did not believe that Ali had a valid constitutional claim. And so the Ali case was not put on the list of cases to discuss. Now, one of the other Supreme Court justices, a man by the name of William Brennan, Brennan went into the Chief Justice's office and said, "Warren, we need to hear this case. The country's talking about it. We cannot let an inferior court decide this. We, the Supreme Court, have to have the last word." And Chief Justice Burger said, "Well, the only reason you want to hear this case is because it's Muhammad Ali." And Brennan said, "You're damn right. You're damn right that's why we've got to hear this case, because he is Muhammad Ali, and we've got to decide this case." So Burger said, "Well, you know, my policy is if you guys feel strongly about a case, we'll hear it. We'll discuss it. We'll see if we want to hear this case. I will add this case for us to discuss in the next judicial conference. Is that okay?" And Brennan said, "That's fine. We'll do that." So Burger put the case on the list, and he said, "It's the last case we'll discuss." So the justices went through the list of cases, and then, of course, Burger then told the group, "Okay, the last case we're going to discuss today is this case involving Muhammad Ali." And immediately Thurgood Marshall stood up and said, "I don't want anything to do with this case. I have worked my whole career fighting segregation, and now we have a group of black Muslims preaching separatism. I don't want anything to do with them. I don't want anything to do with this case. And he left the room. So the remaining 8 justices then discussed the case. The Chief Justice spoke about the case first. The justices then all spoke in order of seniority, meaning that the newest justice, the junior justice, spoke last. They then took a vote in reverse order as to whether to hear the case. And the vote was 4-4. Now you would think the case would be dead. But notice in your notes, the crucial rule of 4 applies. The rule of 4. Make sure you star that. The rule of 4 is essentially what the name tells you, and that is that if at least 4 of the justices want to hear a case or hear a controversy, then it is accepted for Supreme Court review. So think about this another way. In reality, 4 of the justices wanted to hear this case, and 5 did not. I've told you that there are many, many, many examples of a minority having the power to overrule a majority. And here is yet another example of this. 4 Supreme Court justices decided they wanted to hear the case, and the case went forward. Now, of course, what happens at this point is the justices let the clerk of the court know that they're accepting this case for review. The attorneys for both sides are notified. The media is notified, and we go from there. So, as your notes point out, that the next stage in this process is for the written briefs to be filed. Obviously, part of that is that the attorneys for both sides are going to summarize their case and summarize what they believe their opponent's major argument is. But if you look down just one line in your notes, you'll notice that in 80% of cases, there are these briefs that are filed called amicus briefs. In Latin, it's amicus curiae or amicus curiae. I've heard it pronounced both ways. It means friends of the court. What this almost always is are interest groups trying to lobby the court. They are trying to influence the court to vote one way or the other, even though they do not have a specific claim in the case. Now, I'm going to deviate. I'm going to move away from the Ali case because I want to give you the best example of this that I can think of. In 2005, there was a case called Roper versus Simmons, and essentially this case involved whether or not Missouri could execute a 17-year-old murderer. The American Psychological Association wrote a very detailed amicus brief, and in this case, they told the Supreme Court justices that given our lengthy study of adult and juvenile brains, we have come to the conclusion that the juvenile brain is fundamentally different than the adult brain. That juveniles act they're more prone to peer impulses. They are less cognizant of the long-term consequences of their behavior. In short, juveniles act with less culpability than adults. According to the American Psychological Association, juvenile brains and brain development does not even begin to plateau until a person is perhaps in their early 20s, and the brain does not fully plateau until one's middle 20s. And so what the American Psychological Association was urging the Supreme Court to do in Roper versus Simmons was, do not allow this execution to take place. Yes, Mr. Simmons did a horrible thing. He kidnapped his neighbor, he hogtied her, he threw her off a bridge, killing her. But in this particular case, it is our belief that the execution of a juvenile murderer would constitute cruel and unusual punishment. So please, in this case, they urge the court to not execute Mr. Simmons. And that is exactly what the Supreme Court decided in that case. The Supreme Court took the American Psychological Association as experts and expert testimony, and they used that in their majority opinion, which said, Missouri, you are not allowed to execute juvenile defendants. Now, in the next video, I will finish up deciding a case. Have a great day.